Well, hello there, you beautiful, beautiful, amazing, wonderful people. It's the midweek hump. I've just realised it's midweek hump. I'm so excited. Everybody loves a midweek hump. And we are kicking off the day with Idaho 4. Because there's some things in the Idaho 4 case which I don't think people are quite getting. Now, just to address some housekeeping rules. Housekeeping rules? Not so much rules. Look, obviously there's the guilters. There's the guilters here, and then there's the non-guilters. We'll simplify it. Guilters, non-guilters. There are some sort of intermediate levels of Idaho 4 coverage and people involved, but ultimately, guilters, non-guilters. And I am a non-guilter. And because I'm a non-guilter, we get other channels, we get people in the comments who turn around and they'll say things such as, you spread misinformation. If you're someone who goes into the comments, whether it be on here or whether it be on Twitter or X, whatever it's called now, and you will accuse channels like mine of spreading misinformation, grow some balls, put down in the comment, rather than putting you spread misinformation, put what the misinformation is. Put the misinformation in the comments that you feel this channel, for instance, is spreading in the Idaho 4 case. I would love to know, because it's quite funny when you hear these people who are saying that you spread misinformation, then going on and they will say, oh, they're insane because they think Brian Koberger might not have done it. He even returned to the scene of the crime in the morning and his phone was pinged in the area. You are a fucking moron. So I ask you one more time, if you believe that I am spreading misinformation, please put it down below what you believe that misinformation to be. If you can't do it, don't say it, because it's boring. It's very boring. And you're wrong. Anyway, let's crack on. Because, like I said, there's been some things happening in the Idaho 4 case. And I know that I said, look, if there's nothing new to talk about in the Idaho 4 case, we're not going to go back over old stuff. We're not going to recycle stuff. There's enough channels that are now starting to recycle back from the right beginning. And it's a good thing to do, because there's some people who weren't here right at the beginning. And they may have only just sort of got on board with the case and started to follow it sort of late in the game. So channels like Lucky, for instance, he might be going over the older stuff, but he's doing it to the newer audience. So if you want to hear what's going on, go and check out channels like Lucky, for instance. A.R. Hayes. But look, what we are talking about here is the most recent situation that is obviously going on in this case that is represented by the court documents. Because I think we'll do court documents and we'll talk about what's going on, and people will listen, but they don't fully understand. They don't fully understand exactly what the court documents are really talking about. They don't, if you haven't got a degree in law, it's hard sometimes to follow what is going on. And yes, you can go and listen to the likes of that sexy guy over at Lawyer You Know, for instance, and he might go over the docs. But again, people, the layman, may still struggle to understand and interpret what is going on. And you still see people, even with these latest docs, for instance, like the doc that I went over yesterday, there are still people who are interpreting what is being said in that doc as Ann Taylor trying to tamper with the jury. But what they don't understand is that's what the prosecution want the public to believe. This is all part of the process. This is all part of the trying to push a specific ideology within this case. That's what the prosecution have to do. When it goes to trial, that is what they have to do. That's their job. Their job is to try to get a guilty verdict against the person that they have brought forward and said, this is the guy that did this crime. And that is all part of it. It is all part of it. I want you to look at these two important docs, because these two docs, one from the prosecution and one from the defense, they're basically talking about the exact same thing, but both sides of the argument. And you have to decide whether, if you're a guilter, then you're obviously going to jump on Bill Thompson's bandwagon. But what I think people are doing, they're jumping on Bill Thompson's bandwagon without taking Ann Taylor's argument into consideration, because they've already made up their mind, and that's how bias works. Biased people are not interested in both sides of the story. They've made their mind up. So what they will do is they will simply look for things that solidify their thought process. They're not interested in the bigger picture, and that's the danger. That's the danger, and that's why Ann Taylor reached out and did what she did with this survey. Now, what people are trying to now say is that this survey was jury tampering, and this ideology has been exacerbated by Bill Thompson's latest filing in the court documents. But people are just now deciding to listen to what he is saying and thinking, well, he's right. She's tampering. That's what she's doing. But is she? Do people genuinely think that if she was actually tampering with the jury pool, if she was going to the public with details that were covered by the non-dissemination order or the gag order for those laymen out there, do you think she would get away with it? Do you genuinely think there would not be repercussions, legal repercussions to that? You've got to understand that when these docs are going backwards and forwards, and when they're releasing some things to the public and not releasing some things to the public, there is generally a reason for that. So let's just very quickly look at these two opposing documents and fully get to grips with what is going on, so people can understand that the tactics being used by the prosecution are dirty. And I'm not saying that because I'm a supporter of Brian Kohberger. I'm not a supporter of Brian Kohberger. Not at all. And I'm well aware of the multiple things that they will have to cover in the trial, and there will have to be some questions answered. But let's not forget that it's not, the burden of proof isn't with the defense. The burden of proof isn't for them to prove he didn't do it. It's for the prosecution to prove that he did. And if there isn't enough evidence to prove, and it is just circumstantial evidence, then the only way that they are going to get a conviction with circumstantial evidence is to act on the bias that they can create. So people's mentality will be, oh, well, it could be his car. It could be his car there. I know they can't prove it 100%, but you know, he had issues with women, and he potentially went into that colleague's house and put cameras to watch her. And do you see what I mean? This is a sales pitch. I've said this countless times. People purchase on emotion. That's what they do. People purchase on emotion. And this, in the courtroom, is going to be a sales pitch. And it will be whoever can sell their story the best and latch onto that emotion. And that's why it is so important for the likes of Ann Taylor, when they're in these kind of situations where they've got someone's life in their hands, that they do absolutely everything they can to prove that the process that they're going through is fair, that it isn't bias. So when it does go into the courtroom, it isn't about circumstantial evidence that is basically could be, couldn't be, being leveraged because of stuff what has been out in the media that has caused a bias towards the client. Do you understand? It's that simple. We can see it. It is rife in the community. Rife in the community that there are so many things that are not yet proven as fact. But people don't understand that. People do not understand that the stuff that is being pushed forward isn't fact, but they're using that to, in their own mind, convict a guy and potentially send him to death. And that may not ever be proven. It may not ever be proven beyond a reasonable doubt that the white Hyundai Elantra was Brian's white Hyundai Elantra. It just may not ever be proven. but circumstantially, it could be. And if you pair that with the aforementioned issues that have arisen in the media, then that is going to form a bias that makes people think, well, it might be, and it's likely to be, so let's convict on that. And you have to ask yourself, is that then right? So these docs, because I digress. So what we got here is this doc, look. So bring this here. So this comes now, Brian C. Koberger, borrowing through his counsel of record, and hereby moves his court to rescind the order on March 22nd without providing due process. On March 22nd, 2024, late on a Friday afternoon, the state filed its motion to prevent contact with potential jurors. The motion included attachments. The late Friday afternoon filing was a strategic action by the state. Now, I'm not going to read this word for word, but what this is basically saying, in a nutshell, is that the prosecution knew of the survey that Ann Taylor was putting forward to the public. They knew. She used a company that has been used in Idaho previously. The methodology in what she was doing was something that had been tried and tested and been successful over 2 decades. And again, it had been used in Idaho previously, and they were fully aware of it. Fully aware of it. Absolutely fully aware of it. She didn't do it behind anyone's back. She just went out and did it. And the idea here is to go out to the public and talk to the public and say, look, what have you been subjected to? Have you been subjected to this? Have you been subjected to that? And how do you feel about it? And she is in her right to do so. Absolutely in her right to do so. So if we get rid of this, this is the other doc. So this is from the other side of the fence now. So this is Bill Thompson and co. basically saying that what you did was going against the non-dissemination order, because within your questions to the public, you divulged factual evidence that was covered in the non-dissemination order. So he's been clever with his verbiage there, because he's basically trying to make it look like you've gone to the public and you've shared actual facts that are covered and you're not allowed to discuss with the public, and therefore you are tampering with the jury. That's what you're doing. So I ask you, do you genuinely believe that Ann Taylor has gone to the public and divulged factual information surrounding this case with the public? Do you believe that she would do that? Someone if in her position, would she do that? And what do they mean by that? Because ultimately what we're saying is the stuff what would be considered factual would be the stuff that she has received and is confirmed as factual in her discovery. So it would sit there in her discovery. But how about if she hasn't received factual information surrounding the neighbour or the colleague, who Brian Koberger potentially went and fitted cameras in her house to spy on her? So Ann Taylor could go to the public and say that. She could go to the public and say, have you heard that Brian Koberger... Now, if that's somewhere in here being floated around, but it's not confirmed as factual, is that wrong? Or is she able to ask whether someone has been subjected to certain information and see how they feel about it? It's like the white Hyundai Elantra, for instance. If that hasn't been proven via discovery that the white Hyundai Elantra is in fact Brian Koberger's, then she could ask the public, do you believe that the white Hyundai Elantra is Brian Koberger's? That's the issue here. The issue is, if that white Hyundai Elantra, and I'm just using this as, this may not even be any part of it, but what I'm getting at is there's a difference between circumstantial evidence, things that have been thrown out into the ether by the likes of media that you and I are privy to, that is not confirmed as fact. And Ann Taylor can go to the public and speak to them about things that are not confirmed as factual, and find out whether the public have been subjected to it and how they have, and how that has landed with them. She obviously cannot go to the public with anything that is confirmed as fact. So if they had proven beyond a reasonable doubt that white Hyundai Elantra, that was seen on camera in Moscow, Idaho on the night that this happened, and that is proven, proven in discovery, she then couldn't mention that. She can't do that. So I'm asking all of you guilters out there, do you believe that Ann Taylor has done that? The things that have been proven as factual in discovery, Ann Taylor has then got hold of that and put that out to the public and gone to try and twist the narrative on it. And if you believe that, then how is it that there has been no repercussions to it from a legal standpoint? Because there would be. And I feel that it's indicative of a bias community when they're turning around and saying that these people are complaining about being approached. Is that not indicative of a biased community? And does that in itself, beyond anything else, prove that this trial needs to be moved out of Latah County? Let me know down below what you think. Genuinely, whether you're whatever side of the fence you're on, can you not see what is happening here? These are dirty tactics by seemingly a bunch of people who have got their guy. They've been unable to show how they got him. Everything that we see that is currently being used to push guilt as either fabrication or these weird and wonderful stories in the media, from anything from putting cameras in people's rooms and stalking them to being a cannibal and an incel. Fucking hell. It's great. This is what we're dealing with. Let me know down below, and I'll catch you all in the next one.